Good evening to everyone present here. It is my pleasure to welcome you all to the TSG Labour Law update for this month of April 2023. So before we start right into our session, let me share my PPT. I hope it's visible now. Okay, so the first segment is with the amendment. Okay, so with respect to the amendment, we are going to look at the Maharashtra Labour Laws Amendment Act of 2022. So basically, in these amendments, there's a substantial increase in the fine amount where penalties imposed for employees and employers. So the first one is the Maharashtra Industrial Relations Act of 1947. And Section 104 and Section 106 deals with this, where Section 104 deals with the penalty for employees instigating any illegal lockout or strikes or closure or stoppages, where there's an increase in the fine amount from rupees 5 lakhs to 10 lakhs. With respect to 106, that is Section 106, any illegal change imposed by the employer, then a fine is levied on the employer for rupees 5 lakhs. And in case of continuation in contravention with the provisions of the Act, then every day rupees 5,000 is levied on the employer. Now, the next act is the Maharashtra Labour Welfare Fund Act, where Section 17A, it deals with the penalty imposed on the employer in case of any obstruction in inspection and discharge of the inspector's duties, and also in case of failure to produce certain documents. So basically, there are two categories of offenders. That is the first-time offender, where such a person is imposed with a fine up to 1 lakh, and the second-time offender is imposed with the fine up to 2 lakhs. In case of any absence of adequate reasons, then the offender might be given only the fine alone, where the fine amount is increased to rupees 5,000. Now, moving on to the next act, that is the Maharashtra Matadi, Hamal and Other Manual Workers Regulation of Employment and Welfare Act of 1969. Over here, Section 3 primarily deals with schemes ensuring that regular employment is given to the unprotected workers, where any contravention to any provisions of the Act would actually levy up to 5 lakhs of fine. And in terms of the second-time offenders, the fine amount may be around 10 lakhs as well. In case of continuation of contravention, even after the conviction, then the fine amount extended would be around 5,000 every day. Now, with respect to the next acts, that is Maharashtra Private Security Guards Act of 1981, Section 27 over here deals with the fine amount, which is drastically increased from rupees 500 to rupees 5 lakhs. And these are all with respect to the general penalty for offenses. In case of the Maharashtra Workmen's Minimum House Rent Allowance Act of 1989, Section 10 primarily deals with the penalties for offenses, where in case of any failure to make payment under this act or falsification of accounts or any illegal entry into the account books, then the fine amount levied is increased to around 10 lakhs. Now, moving on to a next segment, which is the circular and notification. There's a circular regarding the implementation of Aadhaar in the ESI corporation. So basically, what does this do is that an employer can feed in the Aadhaar number by registering the details of the employee. And once the employees register, the personal details would be auto-populated as well. And there's another number called as the Ayushman Bharat Health account number. So basically, once the employee gives the consent, the employee number would be generated based on the given Aadhaar number as well. Next is the Telangana Shops and Establishment Act of 1988. So this notification, what does it say? The government of Telangana basically allowed all the shops and establishments covered in the act to be operating 24/7, provided it is subject to certain conditions. That is, the first one is the issuance of ID cards to the employees, and weekly offers has to be allocated to the employees, as well as weekly working hours as per the act must be adhered, and then issuance of overtime wages, issuing compensatory holiday in case the employees attend during any national or festival holiday. Similarly, also providing adequate safety towards women employees and getting their consent when they want to work in the night shift, also providing transport facilities to the women employees. The management also has a duty of care to maintain records and furnish returns as prescribed by the government within the given time. And also adherence to the provisions under the Police Act must be done. And then payment of annual fee of rupees 10,000 for each store to be kept open 24/7 under the Shops and Establishment Act must be done. Now, the next is the extension of medical benefit by the ESI Corporation. So what medical benefits are extended is that the ESI extends all these medical benefits to areas of Impal East and Impal West in the state of Manipur as per the regulation and the Manipur Employee State Rules of 2018. Now, moving on to our next session, that is the quiz. What is the punishment prescribed for the contravention of Maternity Benefit Act of 1961? So we will discuss the answer at the end of it. Moving on to the across the globe news. The French retail giant offers ministerial leave to its women employees. The supermarket giant allows almost 12 days of extra leave for women who experiences endometriosis, which is basically a severe period cramps. And this is actually done to improve the women's rights and also equality at work when the women gives a medical certificate proving they suffer from the illness. So basically they'll be allowed to take 1 day leave per month, so totally 12 days. And also the retail giant offers 3 days leave to women who suffer from miscarriage, also for the women who undergoes an embryo transfer as a part of the medically assisted pregnancy. And in Canada, almost 1.5 lakh workers are on strike over wages. So basically there's this union called as Public Service Alliance of Canada, who has gone out for a strike involving around more than 1.5 lakh workers due to the failed attempts at resolving issues related to remote work as well as the wages. This is considered to be the biggest strike ever in Canada for over 30 years. They are asking for work-life balance as well and work wages along with inclusivity in the workplace. Next, in a knowledge corner, we're going to discuss about the forfeiture of gratuity. This is a familiar term where gratuity actually refers to ensuring that the employees get a token of appreciation for their continuous service in an organization. So basically it is a one-time payment and the limit was fixed to around 10 lakh, above which the employee has to pay the required tax. But now that threshold limit has been increased to around 20 lakh. And who and all is entitled to gratuity? So basically an employee should have done a continuous service for about a period of 5 years. And what are the circumstances in which they can claim gratuity is that on resignation, on retirement or disablement due to a disease or accident, or voluntary retirement or termination. So these are the circumstances in which they are entitled to gratuity. So what exactly is the forfeiture of gratuity? So basically the gratuity can be forfeited when an employee is terminated for an act of misconduct or violence on his part, and also terminated for an offense involving moral turpitude. So what are the preconditions that is required for forfeiture of gratuity? So basically the first and foremost is that the employee should have suffered a financial loss. And the employer cannot forfeit the gratuity without getting substantial proof of damage regarding the property or business of the employee. And also before the forfeiture of gratuity, the concerned employee must be given an opportunity of being heard. So basically the employer should follow the principles of natural justice. And once that is done, the employer can pass an order to either partially or wholly forfeit the gratuity. So what are the punishment for wrongful withholding of gratuity? Wrongful withholding of gratuity is taken seriously in law, where any non-compliance would attract a penalty. So basically the penalty will extend to around 10,000 rupees. And in case the offense is continuing, then every day 1,000 rupees has to be paid by the employer. So with respect to certain case laws, the Delhi Cloth and General Mills Company Limited versus Workman, over here the court has held, in case the workman is found guilty of a serious misconduct, okay, due to any violence against the management or his office peers, near the place of employment, then his gratuity can be forfeited in entirety. The second case is the Parmali Valence Limited versus State of MP and others. Over here, the employer need to produce certain materials in order to demonstrate that they have incurred a loss due to the employee. Suppose if the employee is unable to prove that, then the forfeiture of gratuity cannot be sustained. In this case, that is Union Bank of India versus CJ Ajay Babu. Here, the respondent was an employee of the appellant bank. And basically, he was dismissed from service due to the disciplinary proceedings initiated against him. He asked for his gratuity to be settled, but since his misconduct involved a moral turpitude, his gratuity was forfeited. So what happened is that, aggrieved by his forfeiture, he did approach the Honorable High Court and stating that he's entitled for gratuity as there was no financial loss to the bank. The respondent also approached the Supreme Court, and the Honorable Supreme Court held that, see, forfeiture of gratuity is permissible only when the bank has incurred any financial loss due to the misconduct committed by the employee. And that forfeiture must be to the extent of the loss that is incurred by the bank. Now, moving on to the next case, that is Siaram Basanti versus Chhattisgarh Rajya Gramin Bank. In this case, the petitioner was dismissed from service because of a departmental inquiry. And again, he asked for his gratuity to be settled. But the bank told that he's not entitled for gratuity because it is to be considered as a way of punishment. Again, the employee approached the Honorable High Court on the account of saying that the gratuity cannot be forfeited. The High Court also opined that the gratuity can be forfeited only, again, if the financial loss has been incurred by the respondent bank. And in fact, to quote the exact from the judgment is that the forfeiture of gratuity is not automatic on dismissal from service. It would be unlawful to forfeit the gratuity without issuing a show cause notice to the employee. So basically, every employer must follow the principles of natural justice, giving an opportunity to the employee to be heard, and also gathering substantial proof. So the court in this case held that gratuity has to be released to the petitioner. So next in the Did You Know segment is that a Chinese employee actually wins 365 days of paid leave at lucky draw and office party. So basically an annual dinner was conducted by the company after Corona to reward its employees and also to boost the employee morale, where one Chinese employee was lucky enough to win 365 days of paid leave. Now, moving on to the case law section. So we're going to discuss about the Ruchika Social Service Organization versus Binaya Kumar Suwar. So in this case, basically the respondent was dismissed from service and he raised an industrial dispute where the court ruled in his favor, granting him the reinstatement with all back pages. So challenging the same, the petitioner then filed a writ petition. And since no stay was granted, the respondent filed a criminal miscellaneous case before the judicial magistrate under section 15 clause 2 of the Payment of Wages Act. Over here, due to the maintainability issue, the same was dismissed. And once it was dismissed, the Honorable High Court held that Section 15 Clause 2 will be applicable only when the wages are not paid in full, or it is partly paid, or it is paid after much delay. The court further held that it is better to approach the appropriate forum, which is the Labour Court under Section 29 of the Industrial Dispute Act, and therefore squash the criminal case. The next case is the MTNL versus Deputy Labour Commissioner. So in this case, the employer was required to pay towards the cess, penalty and interest under the Cess Act of 1996. And also under the Rule 14 of the cess rules, any amount that is determined by the assessing officer must be paid by the employer as a precondition to prefer an appeal before the respondent. But since the petitioner did not deposit the required amount, the appellate authority dismissed the appeal on that ground alone. Again, the employer filed a petition challenging the order and asked the rule to be ultra vires. But the Honorable High Court of Delhi held it is a settled law that a rulemaking authority cannot frame a rule which is beyond the power conferred by the Act. So basically, the appeal has to be heard even on merits, even if the petitioner did not deposit the entire amount as per the rules. Now, the quiz question which I asked, whether what is the punishment prescribed for in contravention of the Maternity Benefit Act? The right answer would be 1 year. So 1 year of punishment is prescribed. Now, moving on to our Lex Posh segment. So we're going to discuss Fauziya Rubani with Delhi Commission for Women, where in this case, an employee made a sexual harassment complaint against the senior manager, so the DCW, which is the Delhi Commission for Women. And the DCW asked the employer or the company for the matter to constitute an internal committee, IC, in order to inquire into this matter and as well as to submit a status report within 30 days. Meanwhile, the employee was also terminated, stating unsatisfactory performance. But what happened was that the employer filed a writ petition challenging the termination order. And the company also failed to appear before the court, even though several notices were issued. So finally, the Delhi High Court held that absence of not constituting a IC, when they have to be constituting, they were directed a penalty where 50,000 has to be paid by the employer. And also the DCW, Delhi Commission for Women, can actually inquire into this matter and find out the truth behind it. Now, moving on to the upcoming events in this Lex Posh. On 19th of May, IC Posh, that is one-day specialized training program, is going to be held, where the speakers, Ms. Madhuri ma'am, who is the mentor of Lex Posh, as well as Dr. Saras Bhaskar, counseling psychologist, is going to be facilitating. So I would request everyone to register, so you get to know a lot of things about the Posh Act. That is how to handle the complaints and to also conduct an inquiry. So this is happening on the 19th of May, 9:30 to 5. And the next program is Be Aware Online Sensitization Program and Posh Act. So this is going to be conducted on 29th May. You get to know the overview of the Posh Act. So please do register. For the very last segment is the complaints report. So this is the complaints calendar. And since we'll be sharing a PPT, you get to know the dates on which complaints has to be adhered to. So with this, I'm finishing my session. And now moving on to the next program, that is in conversation with the HR